Brendan, good evening and welcome. Could I start by asking if you could tell us about yourself and your practice as well?
Okay, so this won't be a long introduction. I've been in practice for about 22 years, commercial civil litigation. I was a bar council member for 8 terms and chairman of the Kuala Lumpur Bar for 2 terms. And about 10 years ago, when I was chair of CPD at the Bar Council, we started this thing called the Advocacy Training Program. And since then, we have been conducting advocacy training locally and internationally. And I'm currently the chairperson of the IATC, which is the International Advocacy Training Council. So I know you've had a lot of distinguished speakers before me, but the slight difference is I've spent a large part of my life in training sessions here and around the world, listening to young lawyers, different accents, different styles, and analyzing how they can be improved upon and finding effective ways to help them improve on their advocacy.
And Brandon, in your time as an advocacy trainer, what would you say are the main points about advocacy that you think young lawyers should know at the start of their practice?
Okay, so the most important thing, and this one, a lot of people who are senior need a refresher about this one major overwhelming point is this. It's important to realize very quickly that it's all about the decision maker. It's about the judge or the arbitral tribunal if you're doing arbitrations. And it's never about the advocate. It's never about what you want to do. It's entirely about how to present that case in the most effective manner to enable the judge to understand you in the fastest and the most effective way and to persuade that judge that your case ought to succeed. So it all starts with that rewiring of your brain, that it's not about what you want to do. It's about, the first question should be, how do I do this for the judge? So can I just put this in an example? For example, when you are submitting and the judge interrupts you and asks you a question, and that question gives you the impression that the judge, she doesn't really understand your argument. Now, what naturally your first thought would be is, how could he possibly not understand my argument? It's so simple. Has she not read the submissions? That's a natural thought process, but an effective advocate never thinks that way. An effective advocate immediately thinks, this is my fault. This question comes because I made a mistake. I did not present this case clearly enough. And then quickly dive into another way of presenting it that is clearer and simpler for the judge. So can I maybe make 4 points? What is important to all judges are 4 things, major things. The first is get straight to the point. Judicial time is at a premium. There is no time to waste. No judge is willing to sit back and say, okay, Greg, take your time. Take the next 3 hours and entertain me. No judge will ever do that. If you think your daily schedule as a lawyer is bad, it's nothing compared to a judge's schedule, a KL judge's schedule. Second point that most judges want you to remember is simple and clear. Everything needs to be simple and clear. Advocacy and judicial decision-making are the same. They're interrelated. Judgments need to be simple and clear. Advocacy needs to be, therefore, simple and clear. Now, this is a very important point to make for young lawyers, because the greatest challenge any law graduate has is, having studied for 5 years or 3 years or whatever it is, they now have to come to the realization that after all this studying and accumulating all this wealth of knowledge, your role is actually not to spout complicated legal principles or lengthy, complex submissions. Your job is the extreme opposite. Your job is to spend time taking all that complicated factual matrix, all that complex law, and distilling it into simple, clear points for the judge. That's our role. So the earlier you understand that point, the better, because you can't go before a judge and lay before them a very complex scenario. It has to be made simple. I learned this very early in my life because the person I worked for had a very uncanny ability, and if we have time, we'll talk about that person, uncanny ability to present something in a very simple, very clear way. Like if the Court of Appeal gave him 1 hour, he could do it in an hour. If the Court of Appeal gave him 15 minutes, he can do the same thing in 15 minutes. Very simple, very clear. It is an important realization to have that the advocate does all the work, not the judge. And a lot of the judges who I deal with complain that lawyers throw things at them and, judge, you work this out. So the submissions are not drafted in a way to help the judge. It's just throwing the facts, throwing the law. Okay, judge, you decide. If the judge has to do the work, I think you are losing that case. The third important point of the 4 is relevance. Everything you do in court must be relevant to the issue that the judge needs to determine. If it's not relevant, you are therefore wasting the court's time. So all throughout today's topic, I'll come back to this. There must always be a purpose. Everything you do must have a purpose. And the judge needs to know that you are dealing or addressing one issue that is relevant. If you don't do that, and it's not immediately apparent to the judge, you are leaving the judge hanging, you're leaving the judge wondering, you're leaving him behind. And this happens in court. So anytime you see in court a judge says, so what's your point? Midway through your submissions, you know you've done something wrong, because the judge should not be left asking, so what's your point? So the skill there is always to communicate to the judge at the start what you're going to do and why are you saying this. And the last point I was going to make that is important, a key point, is justice and fairness. A lot of people dive straight into their case and they want to present the law, the facts to the judge, but they forget that the judge is a human being. And judges invariably don't live in a fantasy legal world where they decide legal points only. The real world looks at justice, it looks at fairness. A real world judge actually would like to know the facts and the parties before them. What did each party do? What did each party not do? And whether the law is flexible enough to bend towards a particular conclusion. So it's all about fairness and justice as well. Only in very rare cases would you find judges saying, I'm so sorry, but I can't help you. The law binds me to do this. Most of the time, they find a way to rule in favor of who they feel in terms of fairness and justice ought to succeed. So the last point, I suppose, was don't treat each file as a legal matter. It is to be presented in a way that wins the battle on fairness, on justice, and the law. And we'll talk about narratives later as well. Yeah, Greg?
Now, thanks a lot, Brendan. That's very helpful, putting it in a nutshell. You indicated when we were preparing for the session that you wanted to speak about effective witness handling, and in particular, effective examination in chief and cross-examination. Now, if I can maybe just ask a few questions about examination in chief first. In today's practice, we conduct most of our examination in chief by witness statements. What do you think are the most important points to bear in mind when preparing a witness statement?
Okay, so a lot of the lawyers, young lawyers who come for our courses, they complain, why are we doing examination in chief orally when everything's in witness statements? So the answer is very simple. The same principles apply. So the 2 points I want to make is this. The first point is, and the most important point is, the witness statement is only supposed to be the oral examination in chief reduced into written form. It's a saving time mechanism. Instead of coming to court, doing evidence in chief, ask the question, answer, ask the answer, it's reduced into written form in the form of a witness statement, but it doesn't change how examination in chief is supposed to be conducted. Your witness statement cannot contain questions that are leading. It cannot contain hearsay evidence. It cannot contain questions and answers that include matters not pleaded, for example. And if you were the opposing side, when you receive the witness statement, you look out for all these things and you object to them at the start of the proceedings. The second point is that evidence taking is not a separate process. And a lot of senior lawyers also forget this. Advocacy starts from when the trial starts. So no judge decides the case at the end when the judge reads the written submissions or the oral submissions after trial. It starts from the day one of trial. They hear the witnesses and they start forming a view as they go along. By the end of the trial, before the written submissions go in, they roughly know who they want to win anyway. The submissions are just to help them justify the decision they made. So the evidence-taking process is not a separate process. It's still advocacy. It's still about persuading the judge. And it's about how you present the evidence. But in this case, the difference is it's through the witness, either in chief or in cross. Correct?
Right. Brendan, some useful points in terms of preparing a witness statement. But I'm just interested, Brendan, in terms of the structure of a witness statement. In your view, what is the best way to structure a witness statement to ensure effective presentation of the witnesses' evidence in chief?
Okay, so bearing in mind the 4 points I made at the start,
Right.
what the last point was justice and fairness. Before you even start drafting your witness statement, you must have a case theory. You have to formulate your case theory, and I recommend that case theory must be a legal one, but you cannot forget justice, you cannot forget fairness. So as part of that legal case theory that you're forming, you can't forget justice and fairness. It must be part of that process. And then you produce a narrative, a general theme that will govern and it will guide everything you do and everything you present to the court. Yeah. And so from that start, when you prepare your witness statement, all the way to the end of your submissions and your written submissions and your oral submissions later, follow the same case theory, follow the same narrative. Yeah. And you always keep sight of that. And you must always come back to that same case theory, same narrative. And make sure every witness statement follows that same narrative and general theme. Second step you must take is then you formulate a structure. As I said earlier, purpose is important, relevance is important. So the structure, find the most effective way to tell the story. And telling the story in a simple and clear manner. Again, I made that point as well. It must be simple, it must be clear. And there are many reasons why it should be simple and clear. And most importantly, the point I made earlier, judges should not have to work for it. We have to make things clear because they've got 10 cases a day. The simpler and clearer we make it for them, the better we are and able to persuade them that our case is correct. Explaining the facts in the most effective manner, simple, clear points, one at a time in a structured manner. One at a time is a very important point. Never give a judge convoluted sentences, a lot of evidence in one sentence. Again, this brings you back to your 3 years or 4 years or 5 years of law school. People wanted you to write like a lawyer, and to them, writing like a lawyer means long sentences, big words. It is actually the other way around. It's actually short sentences, simple language. So to all those of you who feel your English is not so good, or your BM is not so good, it is perfect for a young lawyer if your English is not that good, because you're supposed to make it simple. You're supposed to make it clear and use very simple language. I'll get to that point later as well. Now, as you know, each case is different, so I can't tell you how to do every case. But what I would do at the start was I would have a drawing board, maybe not an actual whiteboard or an actual board, but a piece of paper. And then you lay out the case in a narrative form first, the story. Then you work out how to present that story. And every case will be different. In some cases, the chronological sequence of time is naturally the best way to present it. But in some cases, it's best to present it issue by issue because there's so many different issues that have different chronology of time. So I can't tell you which is more effective, but you must ask yourself that question. What's the most effective way to present the evidence? So up to this point, you're still not writing anything down yet. You're still just doing a drawing board. The next question you ask yourself is, which witness is competent to present which parts of the evidence? And in some cases, Greg, for example, is the main CEO. He knows the whole story. Everyone else is just subsidiary and can tell smaller parts. But in a lot of more difficult matters, not one person can tell the whole story. And it's 5 different people who have to tell a story in 5 different parts. A witness can only give evidence to what he's competent to give. So personal knowledge. So you put in stuff that Greg doesn't know, he's going to be whacked in cross about his personal knowledge. He doesn't know anything about this paragraph or that paragraph or this paragraph. So it's important to first work out who can say what and at which point of time. And then once you've got all that laid out in your drawing board or your piece of paper, then you work out which witness goes first, followed by which witness, followed by which witness in the most coherent manner. A lot of people today for trials present evidence based on who is available or who will make a better witness first, or who will be struggling, so I need more time to prepare that witness. So you got a date in March, you got a date in April, you got a date in June. Okay, I'm going to keep the worst witness for June because I need more time to prepare that person, or he needs to hear what other people say. But that's not the way it's supposed to be done. It's the narrative for the judge. And I'll get Zah to show a document later. But it's all about the judge again. It's not about which witness you think should be reserved for later. It's about how you present it to the judge to understand correctly. So if you leave someone for the end, the judge is not following your entire story in a organized, coherent manner. And next step would be purpose. Have I covered all the areas I need to cover? After you plan all your structure, next comes the drafting. And the drafting is the most important part. But again, you need to remember this, you are not giving evidence. So it's a witness statement. The temptation is there to draft it for the witness. So everyone does it. I know they do it. Everyone drafts the witness statement first, sends a draft to the client, and then meets the client. That is quite possibly the wrong way to do it. It should be no draft, interview the witness, see what he or she has to say first, then discuss with that person, align him into the way that you want the evidence to go, then you start drafting. That way, the witness gets comfort that you are drafting his witness statement, rather than here's the draft, and then he has to understand what you are saying. Yeah. So always have that first meeting or interview with the witness first. Second point about drafting is draft at his competence level, using language that he can understand and he can defend when he is cross-examined. Let him change or modify anything if he is more comfortable saying it this way or that way. What you really don't want in cross is this, the counsel asking your witness, what is the meaning of this word insinuation that you have used in Q&A 3 in your witness statement? And then the witness struggling to explain what insinuation means because he never used that word. So those are the key points I have in mind when I draft a witness statement.
Okay. Brendan, my next question is, how do you typically prepare for an examination in chief of a witness whose evidence is not taken as read?
Okay, same as what I said earlier. Everything's exactly the same. The thought process is the same. But the difference is that you have to ask yourself, what evidence you want to get from this witness? What evidence can he competently give? And in what sequence you want the evidence to come out? And everything else should be the same. Yeah, so that's what I would do for. I don't see much difference between doing it orally and doing it in written form. But there are obviously skills involved, advocacy skills involved in asking the question, but we can come to that later.
Right. When conducting an examination in chief, I think everyone can appreciate that the advocate should ask open questions to allow the evidence to be expressed, like you said, in the witness's own words. Apart from asking open questions, Brendan, what are the other techniques that an advocate could adopt to ensure that the evidence in chief of the witness is effectively presented? In particular, Brendan, I just wanted to know, like in asking open questions, and how do you prepare for a situation that the witness does not astray from the question? Okay.
Important question, because open questions mean I ask a simple question and the witness has to answer. So that's why it's always a danger. We have no idea what they're going to say. No matter how much you prepare them before court, you don't have any control over what comes out. So let me take a step back for the more junior pupils listening in. When Zah says open question, what he means is, for example, what did you have for breakfast? Yeah, the question doesn't contain the answer that he wants me to give. So what did you want? What did you have for breakfast? The witness can say anything he wants. I don't know the answer. Judge doesn't know the answer. So you're only allowed to ask an open question in examination chief. You can't ask a leading question. So a leading question would be, you had eggs for breakfast, didn't you? Yeah. The answer is in the question. So the witness just sits there, smiles, and says yes. So naturally, that's what the court doesn't want. The court wants the witness to give the evidence, not the lawyer. So the lawyer cannot be putting words in the witness's mouth. So you can't ask leading questions in examination chief. But many advocates, even the more senior ones, they misunderstand what it means to have no leading questions in examination chief. It means you can't lead the evidence. It relates only to the types of questions you can or cannot ask. You cannot suggest the answer. But that doesn't mean you can't control the flow of the evidence. It doesn't mean you can't guide the witness as to what area of evidence you wish to get from that witness. So examination chief is not let the witness speak in absolute terms, but it means let him speak, but you can guide him. So I'll give you an example. So the question that Zah asked was, if the witness strays away from the area of evidence you want her to give, what can you do, right? You can do everything. You can control the evidence. So what I would do is, there's nothing wrong with politely interrupting her and saying something like this. Miss Janice, before we go to the evidence about the agreement on 1st of October, could you please first let the court know, were there discussions that took place before 1st of October? Then let her answer that. Who was involved in those discussions? Let her answer that. When did these discussions take place? Let her answer that. Because what Zara is saying is, this is what I want the court to hear first. But she goes off and starts talking about the agreement. So you can politely pull them back. Yeah. Where were the discussions had? And can you please describe in your own words what was discussed by the parties on that day, 1st of October? So you control how the evidence comes out. So if they do stray somewhere, there is absolutely nothing wrong with stopping your own witness politely and bringing them back to where you want them to go. And that's an important point, because you want the court to hear the evidence in your logical structure that you have planned. If the witness goes off on another tangent, it's not following the logical structure. You have spent time planning it. She goes off on a tangent. Not good for your case. Nothing wrong with politely putting it. As to the question about techniques on how to present the evidence effectively, I've got 6 points. First being, again, structure. I'll keep coming back. The points are always the same. It's still structure. Plan beforehand. Prepare the areas of evidence you want to elicit. How you want the evidence to come out. Which point comes out first. What you want a judge to hear first. What you want a judge to hear second. What you want a judge to hear last. Second point. Plan what you want to get from each area of evidence. So if you're going to ask about the agreement on 1st October, plan out what you want to get from that. Now, as you said, they'll stray away, or even worse, they will say one thing when they're supposed to say 3 things. So they'll forget to give you all 3 points. But you must have in your draft in front of you the 3 points that she must give you. So if she gives you 1 point, you have to keep going. You have to keep asking, what about this? Or what about that? And sometimes they completely forget. They still can't find the 3rd point, and they still won't give you. But you still have to keep going. You can't let go. You can't let your witness not give that evidence if you feel it's crucial. So the way questions and answers work is this. If you ask the question a particular way, the witness may not understand what you're saying. But if you ask it a different way, she may understand. It's all about the keywords that you're using that trigger in her mind what evidence you want her to talk about. Yeah, and I'll come to language in a few minutes, but that's what it is. It's about language. If you ask the question the wrong way, they don't understand what you're saying. If you ask the question the right way, they understand what you're saying. So the 3rd point was guiding the witness. I've been told that the best way to do it is online or in person. You must always look at your own witness. And when she's giving evidence, you must give her some indication that she's on the right track. You should be nodding or something to show her. We've done an expert evidence course, and we've had a half an hour debriefing from our expert witnesses who come and play witnesses, and they comment on the performance of the advocate. And they say that you left me hanging, you left me in a lurch, and then we try and drill down and work out what she means. The witness didn't get any feedback from Zah when he's questioning her in chief that she's saying the right thing. Because Zah's got a stone face. I don't know whether I'm saying the right thing, not saying the right thing. So they actually need you to nod as they're answering, to give them that assurance that they're on the right track. And as I said earlier, if they're straying away, politely bring them back to the area you want. Once you show them that you're guiding them, they become very confident, they become very comfortable, because they know that they can say what they want, you are there to guide them. Yeah. So it's very important that you don't leave your witness hanging. In asking a question as general as, tell us what happened. You know, the witness freaks out, and they've told us this in feedback in the courses. The witness freaks out and goes, which part? Which part do you want me to start with? You know, why are you asking me to do the work? Again, the guidance is so important for them. 4th point is about the language again. Simple, plain language. And this goes wrong in every trial I've seen. Don't confuse the witness with large words and convoluted sentences. You should always use short sentences. And bizarrely, they did a research in Australia. If you use the word vehicle half the Australian population don't understand what vehicle means. So if it's a car, you should just say car. But as a lawyer, you will go, well, what did you do when you entered the vehicle? You know, half of them they get freaked out because they don't know what you mean. And I'm not exaggerating that, because the word vehicle, to some non-native English speakers in Australia and even Malaysia, they don't know what that means. Yeah. So it's not kenderaan, it's kereta. Yeah, it's something simpler. So when you're doing questioning, even in cross, the words you use often take the witness off somewhere else, because they're not lawyers, they are lay people. They don't know these words. So now I'll give you two more examples. You shouldn't say depart the premises when you can easily say left the building. When did you leave the building is a much simpler question than when did you depart the premises. Some people don't know what the word depart means. Yeah, you must accept that Malaysian witnesses come from very different backgrounds of understanding of English. Another example would be the premise upon which you issued this letter is just too difficult. It should just be, what is the reason you send this letter? Yeah, it should be that simple. And the other thing about being simple is one short question at a time, never a long question. So if your question has got the word and, or whereas, or while, or although, or even though, it's too long. It's just one question at a time. One question, get your short answer, move to your next question. That way, the witness is guided. He follows your cue. He just answers your question, and then he moves to the next one. They don't like being asked the general questions. Describe in your own words how the contract was breached. You know, how are you helping that witness? Yeah. The last point about effective techniques for examination is piggybacking your questions. Piggybacking is a term we use overseas, where you use the answer in the last. You use the answer that the witness gave in the previous answer to the question in your next question. So this is the point where I told you to recall the trial that you did recently. Just assume you are the witness for one of the. Just very briefly, let me know what the trial is about.
It's a contractual dispute, sale and purchase agreement.
Okay,
and
so
also misrepresentation.
Okay, sir. What goods were you intending to purchase?
I intended to purchase a unit within a property.
And when you intended to purchase this unit in this property, what did you do first?
I took a visit at the sales gallery.
And what did you see when you visited the sales gallery?
I saw a lot of scale models.
And what about these scale models attracted you?
The unique structure of the building. Could
you explain this unique structure a little bit?
The unique structure, I would say, is very distinctive. It contained.
In what way?
The design of the property. I was very intrigued about the design of the property.
And is that design anywhere in the bundles of documents before the court today?
Yes.
So that's what you do. So you can see the witness is guided. I mean, you don't have to do it for every question. What I was just showing you the example. So his last answer is in your next question. So it makes him less anxious. The flow flows from there. But again, you must have in front of you your plan so that you don't go off to some tangent as well. But piggybacking is important because it creates a very natural flow. It puts Zah at ease when he's giving evidence. You know straight away that he's being guided as he's giving evidence. Yeah, he knows he's not left in a lurch to explain everything on his own to the judge. Yeah. Okay, those are the 6 points I have.
Right, thank you so much, Brendan. Those were useful points.
By the way, I have no idea what case you're talking about, and I just led the evidence through Zah anyway.
Brendan, in your experience, is there any benefit in having a witness's evidence in chief led orally in full? If so, why and what occasions do you think this is the preferred course?
Okay, so if you already have a witness statement there, my view is never in full. Never lead oral examination chief in full if there's already a witness statement there. So you trust that the judge has read the witness statement. The question would be if you feel there is a significant advantage to having certain portions of the witness statement, the evidence read orally. And that would be something not so common in commercial cases. It's more common in, say, medical negligence. How do they feel? The connection, it's about the credibility. The witness needs to be credibility with the judge. So if you feel that by talking directly to a judge, the judge will observe how earnest, how sincere the witness is, then it's worth considering leading evidence in chief in some of the more material parts of the evidence. One tip, of course, that you can do is, you tender your witness statement, then before cross starts, the judge always asks you, do you have any other questions to add? Right? So what you could do, and this is what I do sometimes, is you could use that portion of the court proceedings to go back. So what I would do is, I would say, yes, my lord. And then my question would be, Ms. Incheza, in Q&A 42, you explained in the witness statement what attracted you to the design of the structure. Could you explain to the court in your own words what is it about the structure that attracted you? So you chose that material part, you refer back to it in the witness statement, and then you ask an additional question. The judge doesn't know it's not an additional question. The judge doesn't know it's something that's already there, but you want the judge to hear it. So you can do that. It's a judgment call. I very rarely sought to do oral evidence, but I do it all the time for experts because experts put in a report. The judge doesn't know from reading it. Sometimes you don't know whether the judge understands or not the expert evidence. So in the 2 or 3 case management before the trial, I always make it a point to ask the judge in advance, Judge, when the experts give evidence, could we have half an hour to lead examination chief of the expert, just so that everyone understands what the expert is saying? And again, you won't go through the whole expert report, but you pick out the material parts of the expert report and get the witness to talk directly to the judge, and there to be a Q&A between the judge and the witness on the expert materials. Because the judge may be too shy to admit he doesn't understand. When the witness starts explaining slowly, he'll go, hold on, wait a minute, let me see if that I can understand. And then there's a to and fro process between the expert witness and the judge. So that's when I definitely do lead evidence in chief orally for expert reports and expert witnesses.
So Brendan, if I can maybe switch the discussion now to the other aspect of witness handling you wanted to speak about, which is cross-examination. Would you say you enjoy cross-examination? And if the answer is yes, hopefully it is. Why do you say so?
For someone who holds the title of chairperson of the International Advocacy Training Council, I enjoy no part of the trial process or any part of going to court. It is stressful. It's very, very, very stressful. But I would say cross-examination is more pleasant and less stressful than examination chief. And it's certainly more pleasant than when your witness is being cross-examined and you have to sit there and take whatever is happening because you have no control. As an advocate, you have no control about examination chief. You've got no control about what your witness is answering in cross-examination. But when it comes to you cross-examining, you have full control. Anything that goes well is to your credit. Anything that goes badly is your fault. So I have very little sleepless nights when it comes to cross-examination because it's all about preparation. Once you are fully prepared, there should be no stress whatsoever. So yeah, in that sense, I enjoy cross a lot more than examination chief.
How do you usually prepare for cross-examination?
Same few points I made at the start. You must have purpose, you must plan, and then you must execute. So it's always about the purpose first, and then the planning, and then the execution. What you should never do is go to court, stand up, and start thinking of what you want to ask. The judge knows immediately you're not prepared. The judge knows you are looking as you're making it up as you go along. Yeah. When I cross-examine, when Greg cross-examines, the judge knows we know exactly what we're going to ask. And if they stop us and say, why are you asking this question? We can answer straight away. The purpose of me cross-examining and asking these questions is blah, blah, blah. So judges can tell if you have no purpose, or you're just fishing around, or you're going around looking for something. Civil commercial trials, you never go fishing for evidence. You must know what you want. So purpose, let's talk about the academic textbook version first. Purpose of cross-examination is, number one, to discredit the evidence of the witness in front of you. Yeah? And in doing so, you discredit the case of your opponent. The second purpose for cross is to bolster your case. Anything that you want to prove or you want to establish. So if someone admits a particular proposition of fact in cross-examination, you can something like that. So the first stage is always to work out your purpose. What do you want to cross-examine for? What evidence can this witness competently give? And what do you intend to achieve? Now, what you must always remember is when you cross and you fail to achieve your purpose, the judge knows. And when you achieve your purpose, the judge knows. So it's very important that when you go on the attack in cross, you must achieve your purpose. If you fail to achieve your purpose when you cross-examine Zah, for example, the judge knows from the years of trial experience, the judge knows he tried, but he never really got the answer you want. Not great. I'm not persuaded. Yeah. So the first stage is always to work out the purpose. And then the second stage, the planning purpose. The planning stage is the drafting. So you know what you want to achieve, but how do I get there? How do I achieve that purpose? Sometimes if you can't achieve the purpose or you've got nothing, you don't touch that area. Because it's worse to go attacking into an area and not achieving anything. It actually reinforces the other side's case. Yeah. So if I ask Greg now, do you agree that you don't know anything about this thing? No, I was there on the day. No, you were not there on the day. Yes, I was there on the day. No, you're not there on the day. That doesn't work. Right? You never win anything. You don't achieve anything from that. Yeah. So all that is worth nothing in court. You could spend an hour doing that, and the judge looking at you going, "What are you doing? You've got a purpose, but you never achieved anything." Yeah. So how I would deal with cross is this: you take the witness statement, and I test that witness statement and the statements made in it in 5 ways. The first thing you check is, is it consistent with contemporaneous documentary evidence? And there's a whole line of cases you need to read about that. Starting with Tindok Besar. The cases say that in judicial reasoning, let me see how I can put this in the most simple way. If there is a document that says A, no matter how much the witness says it's B or C or D, but the document is there that says A at the material time, and it's contemporaneous, the document must stand. Witnesses have an interest to say other things later, 10 years down the line. So any version of events that's not consistent with the contemporaneous documentary evidence cannot be taken by the judge to be correct, unless there's special circumstances and all that. But a judge hides behind this. In judicial reasoning, they hide behind this. They love you showing them contemporaneous documentary evidence that shows A, but the witness saying B now. Yeah. So the first aspect is everything the witness saying consistent with contemporaneous document? If it's not, that's my first line of attack. Second line of attack is his own previous statements, what he has said in previous letters, what he said in previous messages or orally somewhere here or there. Same thing. If it conflicts with his evidence giving today, that's an area of cross-examination. Third area would be his conduct, the way he has conducted himself at the material time. Fourth area is the lack of a document is sometimes just as important. So, and the cases say that, I think there's a David Wong case as well. David Wong, not the judge, but David Wong, the case name, where the case basically says, if you say it's A, any commercial-minded person would have confirmed it in writing. But there is no letter that confirms what you say happened on that day 10 years ago. So the lack of a document is also equally important. And the last one is the lack of conduct consistent with your statement today. So if you say A happened, but your conduct was not really consistent with A happening, then the judge shouldn't believe you. So these are the 5 areas I would test the witness statement and prepare cross on. I give you an example. A long time ago, I did a case in Muar where one paragraph in the witness statement was, I was coerced to signing this agreement. There were two large, when I came to the office of the plaintiff, he then called two large bodyguards to come into the room, and he forced me to sign. I was very scared. Immediately after leaving the office, I lodged a police report. That's what's in his witness statement. That was easy to dismantle because he used the word immediately went to the police station to file a police report. But the police report was filed 5 days later. Yeah. So again, a point for drafting a witness statement, your witness statement needs to be consistent with the documents you already have for trial law. So if you're a junior lawyer and you make that mistake, your boss, Greg, ends up looking really bad in front of the judge because the witness statement says immediately went to lodge a police report, but the immediate was like 5 days later. So very fertile area for cross-examination there. Yeah. So I'll come back to the example later where unfortunately Zahar has to be the poor man who said all that. And I'll show you how to do that later. So how do you cross-examine? The technique's actually very simple. There's only one technique you should follow. It's just you have to set up first all the foundational facts that you have gathered from the 5 aspects I pointed out earlier, all the foundational facts to support your case or your argument, and then you end it with your concluding question, which is the proposition you want to make. Yeah, and that concluding proposition is your submission point. So what you do is you first identify the argument, then you draft that last question. You draft that last question, which is your killer question that's going to be used in your submission. Then you put that at the end. Then you start at the top of the page and you start drafting all the questions that lead to that argument being correct, all the facts that support that argument. And you start by asking all these facts first. And the answers will always be yes, yeah, to all your foundational questions. And then you end with your concluding question. Now, why is that method important? Why do you not just jump to the last question? Yeah. And Zahar, can you just show that thing I wanted to show? And why do we have to follow this method? Why do we waste time? Why do we waste time asking the foundational questions and all that, rather than just jump? I put it to you that you were not coerced. This is the reason. So trials and advocacy is about this. There is a triangle, and overseas in Australia and the UK, they teach their juniors all this. The triangle is very, very important to remember. When you stand up to question a witness, everyone makes the mistake of questioning the witness and getting into a to and fro with the witness, forgetting my most important point I made at the start. It is all about the judge, nothing more, nothing less. So the advocate is asking the witness a question, but his whole performance in cross-examination is to persuade the judge. Everything you do when you cross-examine is to persuade the judge your argument is correct and nothing more. Now, 2 things can happen. If the witness says yes to your question, then you've achieved 2 things. You've achieved the judge understands your argument and the witness agrees with your argument. If the witness says, no, I don't agree, which Zahar is going to do later, the judge understands your argument and finds that the defendant's refusal to accept the proposition to be so incredible that his credibility is affected. That's our only purpose in cross-examination. Yeah. Avoid thinking that cross-examination is about that American TV scene where Jack Nicholson says, yes, I'm wrong. Yeah. You can't handle the truth, and then he explains the truth. Nothing like that happens in real life. Greg, maybe later you tell me, has that ever happened? It's never happened to me. Unless I'm a really bad cross-examination, never, the witness has never gone, yes, I agree, you are right. It'll never happen. They will stubbornly, like Zahar later, they will insist that they are right. But it's the judge who decides whether they're right or wrong, or who's more credible. So your job in cross-examination is to show the judge, this is my argument. It's supported by these facts, and yet he says no to my question. Yeah. So the most important thing you need to remember for all junior lawyers is the question is far more important than the answer in cross-examination. The question, the way you ask the question is so much more important than the answer. The answer is fairly irrelevant if the question is done correctly. Because you, in posing that question to the witness, you are actually taking the judge through your argument step by step. and why his answer cannot be right. Why later, there's no way Zah can persuade you that he was coerced to signing that agreement. And I'll show you that why later. Yeah. So that's the way it should be done. So maybe Zah, if you take it off the screen. And so as not to embarrass Zah, but Zah, let me try this out with the same coercion point. We have to assume that all my foundational facts are true because it's in the, so if he denies any of the foundational facts, I have a document somewhere in the bundle, right? Or something to support my case. So, but the questions I'm going to ask him, the foundational facts are all factually true, but he will still stubbornly say he's coerced at the end. Zah, okay? Zah, you say you were coerced into signing the agreement in the plaintiff's office. This happens in real life in online trials. Okay, so you say you were coerced into signing the agreement in the plaintiff's office.
Yes.
And you say because you felt threatened when he brought in 2 large security guards.
Yes.
And you say in your witness statement, question answer 23, that you immediately lodged a police report.
Yes.
Let me ask you a few questions about this. That meeting in the plaintiff's office, it was on Monday, 12th March, wasn't it?
Yes.
And the police report on page 21 of bundle 1, it's dated Saturday, 17th of March, isn't it?
I have to see the police report.
Yeah, so then I show you and then you have to say yes because it says 17th March. Then next question is, that is more than 5 days later, isn't it?
Yes.
And in between Monday and Saturday, there is no letter from you to the plaintiff to say that you were coerced, is there?
No.
And in between Monday and Saturday, there is no letter from you to the plaintiff to say you felt threatened by 2 large men in the room, is there?
No, there's no letter.
And between Monday and Saturday, you actually had a meeting with Mr. Lim.
Yes.
And that meeting with Mr. Lim was on Thursday.
That's correct.
In that meeting on Thursday, you actually informed Mr. Lim that you signed the agreement in the plaintiff's office.
Yes.
And you never told Mr. Lim you were coerced.
Disagree. I told him.
Mr. Lim says otherwise, and he'll give evidence later. And you never told Mr. Lim that you were threatened by 2 large men.
No.
And coming back to your police report on page 21, you never mentioned 2 large men in the office in that police report, did you?
No.
So you were never actually coerced by the plaintiff to signing this agreement, were you?
Disagree.
This is just a fiction you have created in your attempt to avoid liability, isn't it?
Strongly disagree.
Okay, so the point I'm making is he disagrees. We don't get to say he agreed, but does it matter? It doesn't matter because the judge understands the argument you're making. And from the way I did it, I think all of you understand the arguments I'm going to make in submissions. But the key is the judge at this stage already understands my argument before he reads the submissions at the end. And he's already forming a view about Zah as a witness. How could he possibly be coerced when this seems to be the factual position? Yeah, that's what you're doing in cross-examination. That's the whole purpose of cross-examination. Yes, it's wonderful if you get the answer, but never bank on it. You just assume you're getting the wrong answer, and you do all the work, and you persuade the judge that this witness is not to be believed, or on balance of probabilities isn't saying the right thing. Yeah, okay. Sorry, I'm sure I made it much easier than it sounds, but that's the way it goes. It's to me that simple.
Brendan, could I ask you a question about your notes for cross-examination? Do you usually write down each and every question that you would like to ask in a cross-examination, or do you just have it as a little bit of a form?
Very controversial question. Every senior lawyer will shout at me for saying this, but I write everything down. I write word for word everything down, and every one of the senior advocates out there will laugh at me for doing so. But let me explain to you why I do that. There's 6 reasons. I've actually got 6 reasons. There's 6 reasons why I write everything down. Now the first one is we all draft now on computers. So when you're drafting on computers, you can edit, you can change, you can chop here and there, you can rearrange a sequence. So that's all an advantage. Yeah. When I first started practice, I can't tell you when, but there were no computers. Okay, that sounds a bit old. There were computers, but you didn't have personal computers. There was one computer in the office or whatever it is. So you had to write out all the questions in point form on paper. Then if you didn't come to the right sequence, you crumple the paper, throw it away and start again. Yeah. But you got computers now. So you write out what you want, and then you're free to cut and paste and rearrange them and all that. And that's quite important. That's the first reason. Second reason is I find that when I write out the questions in full, it's like a rehearsal for the day of trial. It's like I'm effectively rehearsing what I will say, how I will say it, and what happens if I get this answer or that answer, and what do I ask next. So as I'm writing it in full, my brain is working on, is this how I would ask it on the day? And then you change it as you go along. Third reason why I write in full is, and this is something you must know happens, each time you read your own work, there's bound to be improvements that you can make on it. The first draft is never as good as the third draft or the fourth draft. I guarantee you when you read back your own work, you can find something that you can improve on. And if you cannot, then as a junior lawyer, if you cannot find something you can improve on in your next reading of your draft, there is a problem. Because every draft you read, so I would recommend to every junior, before you give Greg a draft, you should go through it 3 times before you give it to him. Never do one draft and say, Greg, this is my draft, because it's going to be horrible. You have to go through, you have to do it, print it out, look at it again and improve on it. Anything you do, whether it's an opinion or preparing across your submissions, the first draft is never as good as the third draft or the 10th draft. So every time I go back and look at my prepared cross-examination questions, I am guaranteed to find something I can do better and change the wording to make it better. And the work gets better and better. That's the third reason. The fourth reason is it's a safety net. I found that in my own practice that if I don't write it down, I have to formulate the question when I stand up in court. And there's so many things happening in court at any given time. Yeah, you may not be at your best. You may be a bit tired. Something may have thrown you off. The judge may have scolded you earlier, which all of us get scolding. Your witness may have said something wrong. You are all over the place. And I find that having the questions written down in front of me gives me that safety net. I know what I have. I don't have to take time to think of how to ask the question. Sometimes you ask it wrongly, and those sort of things. The visuals that you give to a judge when you know exactly what you want to ask is also important. The judge watching me cross-examine knows that I know exactly what I want to ask. As opposed to, I don't have any ers and oos and ahs when I'm cross-examining, because I know what my question is. I listen to the answer. I know what my next question is going to be. I'm not drafting or formulating a question as I go along. Now, the main reason why senior lawyers will discourage you from writing your questions out is because they think it's a straitjacket. Once you write your question, you're going to, mati-mati, you're going to follow your script. But that's not what I do. It is, to me, a safety net. It's not a script. It's a guide. I still listen to the witness. I still then think, what should I ask? But I have that safety net of it written out in front of me, and I can do it more professionally. The fifth reason is adjournments or continuation on a different day. You'll find a lot of cases start in February. The next date is like April or May or June. And when you come to your May or June day and you only got point form notes, you will have to then think, what was I going to ask? Yeah, I don't have sufficient brain power to do that over and over again. So I find that when I write everything out, the next time I go to a trial in April, I only have to spend 1 hour preparing the day before because it's all written out. I know exactly what I had, where I left off and what I need to do. So that gives me a lot of comfort. I found in some cases when I did point form, I could not remember what was I going to ask and how, what was the point of asking this? And then you freak out. And then you really freak out because you had a point, but you can't remember what that point is. Yeah. And why spend that time in April thinking of how to ask the question or what was I thinking earlier? Because you got, between now and April, you got many other cases. Yeah. So if it's written down somewhere, it's perfectly there. And I also had a very bad experience when I was in third year of second year. My boss, I won't name the person, old school, he wrote everything down. He lost the notepad. He lost a fully written out point form notepad for 4 days of trial. He could not find that notepad. And there's nothing worse than having to start all over again, because you don't know whether you covered everything. And then you're starting all over again. So I actually have it on my computer. I email it to my junior. Everyone has a copy. And that brings me to the last reason. The last reason is, if for some reason I can't do it, and I fall sick on the day, there are two options. One is whoever the counsel is on the day can just take my notes and run with it. He may not ask the question the same way I ask, but he knows roughly what I was going to ask. Or worst case scenario, my junior will do it. My junior has the questions. Yeah. Again, it's not a script. It's just a guide, and she can ask questions based on that. So those are like the 6 reasons. I know a lot of people don't do it, but I find it works for me. And I also thought I would move from being a young lawyer writing everything out to someone more senior, someone more confident with all the experience. Maybe I just do point form. I can do it on the day. I never got there. Some of us do, some of us don't. After 22 years, I still feel more comfortable with everything written out for myself. But again, it's a question of personality. It's a question of competence, what you want to do. But as a young lawyer, I definitely recommend you write everything out first. And then when you get more senior, if you feel more confident, you can do that. But don't try to be the, for want of a better example, don't try to be the Cyrus Das in your first day of practice. Actually, Cyrus has given up doing trials, so he wouldn't write it. So don't try to jump to the senior position. Always move gradually, incrementally as you build your confidence and your competence.
Brendan, I'm really happy with that answer. Not the Cyrus Das bit, but the fact that you write down your questions, because that's something I do as well. I just had a couple of follow-up questions to that. Do you find that you often commit the questions that you've written down to memory so that you flow better, so that your questions flow better, or do you just sort of rely principally on what is on the paper?
I'm a morning person. So the morning of the trial, I run through my notes, all of it, so that I remind myself what I was going to do. But I don't memorize them, because I will bring them along with me. They're in front of me. But I don't stand up and read it for the first time when I'm in court. I do get up in the morning and I go through the whole thing so that I know what I plan to do. And that's important, because at any given time, he's going to give you an answer that you may have to jump to page 16 of your notes. And you need to know fully what you had prepared to ask. So you need to remind yourself the full picture of what you're going to ask, because if suddenly the witness wants to jump to another area, you know where to go from there. So that's why it's also important to have it all written up as well.
And how long does that whole process of writing down your whole questions, all your questions for cross-examination usually take?
It's a good 3 hours for every hour in trial. So for everything you do, the number of hours you spend in the office is far greater than the number of hours you spend in court. Yeah. The senior lawyers who do it wrongly is the other way around. They spend a little bit of time, 1 hour in the office preparing, and they spend 3 hours in court searching for the answer here and there. Judges don't like that. When they hear me cross-examine or they hear Greg cross-examine, we've spent 5 hours in the office preparing for every hour in court. And that hour in court that I have spent cross-examining is literally 3-4 hours for other lawyers, because we are so sharp and we are so concise and we know what we want to ask. We literally are doing 1 hour for every 3 hours some other lawyer is doing. So judges love that. They just love to see that you cross with such purpose that you're not wasting time. And judges are experienced trial observers. So they know straight away when they see a lawyer who is taking too much time, and when they see a lawyer who is very sharp and very concise and straight to the point, they're very happy. They're so happy. I have never, well, I have in my earlier days, because I was not as good in my earlier days, but I've never in the last 5-10 years ever got a judge say, can you please hurry up? Or how much more do you have to go? I've never been asked, how much more have you got to go? Because it's moving at a pace that they're so happy with. Yeah, because I'm not searching for answers. I know exactly where I want to go for every question. So that's an important thing as well. You need the judge to like what you're doing, be happy that you're not wasting his time. And they're very happy when they see us cross-examine this way, because it's very professional. It's very to the point. Preparation is this. If you prepare correctly, and a lot of people have used this example, you're a surgeon, and I know people talk about surgical precision when it comes to cross-examining. But when a surgeon goes in, he doesn't cut open the body, then start looking for what the problem is, then how do I solve this problem? The cross-examiner, the surgeon, he has done all the x-rays. He's done all the scans. He's read up the medical textbooks as to what he wants to do. And then sometimes even if it's difficult procedure, he'll practice it first. He'll practice the surgery. You see it on TV. They practice on some rat or some pig or something like that. And then they cut open the body. Then they go in. That's what we do. We do all the work in the office. What if he says this? What if he says that? If he says this, what document do I take him to? All that is done in the 3 hours or 5 hours before you come to court. So when it comes up, it's never a surprise. You're never surprised by what the answer the witness gives. And you know exactly what you want to ask next. So that's my analogy with surgeons, which I don't think is that good. But yeah, it's the best I can do.
Now, Brendan, I remember the first time I conducted cross-examination, I was really, really nervous. Can you just share with us, do you remember the first time you conducted cross-examination, and what was that experience like for you?
I've never spoken to anyone whose first time cross-examining was brilliant. We all struggle. Mine was horrible. Mine was very robotic. I'd done a lot of preparation, so much preparation, but it was very robotic. It didn't flow naturally. I still remember I used the word, do you agree, in every single question. Do you agree? Do you agree? Do you agree? I kept doing it over and over again. I certainly didn't understand the triangle. I thought I was just talking to the witness. I thought it was all about me getting evidence from the witness and nothing else. I think I would have spent more time fighting with the witness than listening to the judge is playing with the phone or whatever it is. I completely forgot the judge. Judge had no idea what I'm doing. So I may have got the evidence I wanted, but I'm not sure the judge understood any of my points while I was cross-examining. So that's something I learned as I go along. It's not about getting the evidence. It's about getting the evidence, but also presenting it to the judge for the judge to understand. Yeah, so it was terrible. Back then, there was no CRT, so I'm very safe.
Right. My next question is, Brendan, how would you deal with an unexpected, unanticipated response from the witness during cross-examination?
Okay, so if you prepare well enough, it should be very rare. It should be a very exceptional situation where the answer is something you haven't expected. Yeah. So commercial civil trials are like open book exams. Everything is given to you. There are pleadings. You certainly cannot raise anything that's not in the pleadings. There is documents exchanged, and documents are not exchanged one day before. They're exchanged months before, and they're compiled into common bundles and all that. So there can't be a new document in your face. Witness statements are exchanged at least 1 week before, so you know exactly what they're going to say in their witness statement. So there should, in theory, be no room for surprises when you start preparing for trial. The more you prepare, the less it's possible to encounter any such unexpected, unanticipated responses. You will always be ready for, if he says this, what do you do? If he says that, what do you do? And most of the time, correct me if I'm wrong, Greg, we know exactly what the witness is going to say. Their story is in their witness statement. Yeah, and they won't, if they deviate from the witness statement, you can immediately point it out. Yeah, so there should be very little that does surprise you. But to answer your question, when it does happen, most important thing is never show the court you are surprised. Never ever show the court you are shocked by the answer, because again, it's a performance. The judge needs to believe that you are in control. You can't suddenly go, oh, I didn't realize that was going to be the answer, and then you start struggling, right? That means the judge knows that that answer was not something you planned to get. Yeah, and that affects the credibility of your performance, because you're supposed to know exactly what you want. So whatever happens, you never show the judge that you didn't know this could happen. Yeah. Think fast, because you prepared everything. You know where all documents are. You know what the documents say. You know what the witness statement says. Think fast and counter it by whatever you can. If you cannot find a suitable response immediately, and again, don't kill yourself if you can't. Not everyone can think that fast. I don't think that fast, definitely. I would defer it. I would find a nice way to defer it. And a good way of deferring it would be this. Zah, that's an interesting answer. Let me come back to that in a while. But now let's focus on the events of 3rd of December instead. And then later I'll come back to it. Yeah. Earlier you said it was the plaintiff that asked you to sign the letter. Could you point me to any document where the plaintiff said? So you find your point in counter, but you buy yourself time. You buy yourself time till lunchtime, or you buy yourself time till lunch break, any break you take. Then you ask your client, he just said this, what do I do? Right? So if you cannot find an answer straight away, you find a way to defer it. That's an interesting answer. Let me come back to that in a while, but now let's focus on this. You are in charge, so you can do that. The worst thing you can do is dive headlong in what you think is a good attack, to find yourself getting in more and more trouble. Yeah. So an advocate needs to realize most of the time that sometimes it's always better to take a step back, because thinking about it is more important than just diving into it sometimes. Yeah. And that's also your comfort levels in terms of that.
Right. Brendan, an important rule in cross-examination, I think you stressed earlier, is not to ask a question that you don't know the answer to. Do you think there are any exceptions to this rule? And if so, what are they?
Okay, so we've covered the part where you should never ask a question you don't know the answer to. And sometimes the young lawyers I teach, they get very shocked when I say this. In cross-examination, you don't ask any questions. You don't go looking for answers. In cross, you should know the answer you want. It should be in the question when you ask. It should be a situation where you never need to know the answer. Sorry, you never be in a position where you don't know the answer. Yeah. So, for example, if you're not sure whether the company has got 3 directors or 5 directors, or whether any directors are related to the witness, you should be doing the work beforehand. You should be doing the company search, finding out who the directors are, finding out whether they're related to the witness giving evidence. So all the work needs to be done before the trial, so that you're not left on the day lazily finding out, so how many directors does the company have? So are any of the directors related to you? So you don't know the answer, right? So never do that. So if you put any proposition you want to make, if you want to make the proposition that Zah is related to another director of the company, you do the work beforehand, not start asking him on the day. It should be, in Zah, one of the directors of the company is Puan whatever. Puan whatever is your sister, isn't she? Or your mother, isn't she? That is the question you should be asking. Who, not who is this Puan? It's not what you should be asking. Yeah. When do you ask open questions? Is when you know the answer, and you want to show off a bit, and you want the judge to hear Zah squirm a bit. So in Zah, who are the other directors? Then he has to name the person. And this person, Puan so and so, who is she? Huh? You know you know the answer is his mother. Yeah. So then you're playing games. You're making him squirm, but you know the answer. Yeah. You already know the answer. The exception to the rule of not going where you don't know the answer is when you know the answer, whatever the answer is, cannot hurt you and can only bolster your case. So last week when I was in Alostar, what I was trying to achieve was that there was no evidence in court. There was no proof of payment. Yeah. So I asked about half an hour of questions to establish what steps he took to gather all the possible evidence. So she was the executor of the estate. So, she's not the actual person, so she's the executor. So when do you become executor? What do you do when you become executor? What steps you take? I don't know the answers to this. Yeah, but I know the answers will not hurt me in any way, because all she's going to do is give me evidence of all the steps she has taken to gather all the evidence she has. But it doesn't affect my last question, which is, having done all that, you still couldn't produce any proof of payment, correct? That was never going to be affected, because if she told me she did A, B, C, she did all she can, but she still couldn't find proof of payment. So that's where you can go, because you don't know the answer. But you know the answer doesn't hurt you. Yeah. The other area where you can do that is if you know the answer either way, you have a counter question for it. If she says yes, you've got questions to take her your way. If she says no, you've got questions to take her that way. So when you're reasonably covered on both sides, yes or no, or A or B, so if the answer could be A or B, then you can prepare for A and B, and you're still okay. But if you really don't know the answer, it could be A, B, C, could be anything. You know, you really need to stay away from those questions. Unless you prod gently, you prod a little bit, then you see it's going bad, you come back. But the problem with doing that when you're not so senior is that what if the answer comes up that is wholly bad for you? Yeah, and that's the problem with cross-examination. Cross-examination, you are in control. If an answer comes up that is very bad for your case, whose fault is that? If you didn't ask the question, it's not in the witness statement, no one else is given the evidence, but when you ask that question, that answer came out, it's entirely your fault. Yeah, that is why we stay away from asking questions where we don't know the answer, because once it comes out, we are stuck with it. So you have to keep all that in mind. And I can't give you a definitive answer. It's judgment calls. But if you really don't have an answer, you shouldn't be going there.
Right. Brendan, my last question is, are there any techniques to approaching a cross-examination conducted online? If so, what are they?
Okay. Many people have different views. I don't believe there's any difference doing a trial physically and doing a trial online, except your eyes may be more tired, whatever it is. But you know, there is, in terms of clarity, in terms of the witness being on the screen and all that, there is no discernible difference in the objectives that we do. What is important as a technique that we should already be doing in physical trials, which becomes a lot more important for online trials, is short, simple, clear. It is so much more important online, because you don't want to be meandering around looking for evidence on an online trial. Yeah, you should be very short, you should be very simple, you should be very clear. If the sentence is long in a physical trial, the judge may not mind it. But if the sentence is long on a Zoom trial, the witness may not hear you. The witness might say, sorry, can you repeat that again? And then it's repeated all over again. Short questions, they cannot run away. If the question is very short, they can definitely hear it and they can definitely answer. Yeah, short questions are never difficult. So when a witness doesn't want to answer a short question, the judge gets pissed off. Instead, Zah's question is very simple. Did you see or did you not see? It's not a difficult question. Why can't you answer yes or no? Yeah? They get involved. They get very frustrated. His question is just a simple question. Did you see or did you not see? That's all. Yeah. Did you sign the resolution? No. Did you sign the resolution? It's a simple question. So they end up looking bad, online or physical, if they cannot or they evade a short, simple question. That's why short, simple questions are very compelling for cross. And it's the same you should do for physical trials, but more apparent on online trials because you lose people along the way.
Brendan, could I just ask a final question? What do you think are the steps our junior members of the bar at our firm could take to develop or improve their EIC and cross-examination skills?
Okay, so Greg has paid me to say this. Every time you've got a trial as a young lawyer, and again, I think your firm, I don't think that many magistrate court files or session court file where Greg will say, you go and do this yourself. It'll be mainly assisting for the first 3 years of your life. But an assisting junior should not just sit there and smile and take notes. Yeah, Greg will be busy from now till July. The trial he has assigned you to help him with is in July. He's too busy now to look at it for a July trial. That doesn't mean you as a junior, you can't read the file now. You can't prepare for the trial. You can prepare for the trial. You can prepare a draft of questions for cross-examination. You can prepare a draft of the witness statement for Greg. All these things a junior lawyer should take initiative to do for their bosses who will be conducting the trials. So the more you do it, the more trust and confidence your superiors will have in you, the more work they will give you. The more work you put in, the more work gets corrected and sent back to you, and you learn from that as well. And when your draft is done and you show it to your boss, and he goes through it with you in preparation for his cross, and he changes your sentence, or he changes how you wrote it, and then you go back and say, I wrote it this way, but he said it this way. What's the difference? Yeah, you learn a lot from that. Yeah, so if you feel as a junior you're just carrying bags, going along, you're not doing yourself any justice in that sense. You must immerse yourself in the file. You must do the first draft, the cross, or at least prepare point form for Greg and say, Greg, you must cross-examine this document. In the document, he said this, but his witness statement says this. This is the conflict. Those sort of things. You must. Then Greg will say, well, you draft it for me. Then you draft it for him, and then he'll say, well, good work, but I would have said it this way. And then he will do it in court. And that process is very important. It's a two-way process. And this, again, general advice for young lawyers. It's never about what your boss gives you to do. It's about what you say you want to do. Yeah, it's about how much you want to get involved. So it could be in your second year or your first year because of how much you've helped. Greg might say, DW6, not such an important witness, you do it. I'm sitting here with you, but you do it. And that's great experience for a high court trial, cross-examining one witness. Yeah. So it's important that you immerse yourself in the work and you do the first draft of everything. And again, I'm sorry, but some bosses are different. But most of my friends who are senior advocates, they will sit down with you. They will go through it with you when they prepare. They don't say, okay, I'm going to prepare cross now, leave the room, I'll do it myself. They'll like you with them. Then they'll ask you, so why do you ask this way? What are you trying to achieve? And then they'll redo it for you, and then you learn from that as well. Yeah. So always volunteer to do the first draft of everything. And that's going to, I understand that's the way your firm works anyway. Your firm is not one of those with 1,000 runner files where they get to do trials straight away. That's the reality of practice. So you need to find the experience in this way. Yeah. So it could be 5 years in practice and not done any trials, or it could be 5 years in practice and done many trials, assisting your boss and all that, and develop all the skills. So there are many types of 5-year lawyers, some that done nothing, and some that done a lot of work with their bosses and done their own trials. Yeah. So all I can advise young lawyers is to do it and then see it being used in court and how they asked it.
Brendan, thanks so much.
I'm so sorry it took longer than expected.
No, not at all. We know you have a 7 o'clock appointment.
But we can still do Q&A. My next Zoom is 7 o'clock.
Sure. Then in that case, could I maybe open up the floor to the rest of the firm to see if they had any questions they would like to ask you of their own? We have a few in the audience. Hi, Janice. I notice you're there.
Hi, Brendan. Janice,
do you remember what we are supposed to make fun of David Matthews online in this talk?
Yes,
I can't remember.
Yes, I do. Is he even here?
But he's not here. He's not here, so it doesn't matter.
Yeah, I'm in Penang, Brendan. Sorry, I couldn't moderate this with Greg. I just finished a meeting with my witness. But Greg, Brendan, even during advocacy training, you always cover EIC and cross. We never get a chance to speak to our lawyers about re-examination. And it's always such a struggle. I did a trial last week and the opposing counsel kept objecting to my re-question, saying you can't ask even a follow-up question on re. And it was, I find re sometimes even more difficult than EIC. It's such a struggle. Can you just talk to us a little bit about that?
It's supposed to be a struggle because you only re if the witness has made a mistake or he wasn't sufficiently clear in cross. No, the one thing you shouldn't do is try and answer everything in cross because you've said it in the witness statement. So you don't have to repeat what's in the witness statement. So you only re-examine in areas that you feel needs to be clarified or needs to be corrected. And that's always going to be difficult because the witness already got it wrong to start off with. Yeah, but it is very important in re to avoid arguments. The first question is always to contextualize what he said in cross. So earlier in cross-examination, you were asked this and you said this. That must always be your first question. To avoid any arguments from the other side standing up and shouting, how can you ask this question? So the first question is always earlier in cross-examination, you said you were asked this and you said this. Then the next question can only be, what did you mean by this? or can you explain why did you disagree? That's all you can do. Yeah. Then you have to wait for the answer. And as I showed you earlier with Zah, when he gives that first answer, you can follow up from there because it's still the same context. Yeah. So you keep asking those questions, and the way I asked Zah earlier for Chief and agree are the same. You can't put the answer to him. Yeah. So you can't do this. You can't say earlier in cross-examination, you said you asked this, you said this, but in reality, what you mean is blah, blah, blah. You can't do that. Yeah. So you can say, why do you disagree? He has to answer first. Then you can expand on it. But what do you mean by that? And you have to keep going until he gives you the answer that satisfactorily corrects the problem. And that's the danger. Sometimes you keep going and going, he doesn't get it. Yeah. What you can do is hint to him, ask the question a different way. My go-to way of trying to salvage that is to go back to the pleadings. You are saying this today, but can I refer you to paragraph 2 of the paragraph 2.6 of your defense? Here it is said blah blah blah. Can you explain why there is a difference between what you're saying today and what? Then maybe he'll jog his memory. Yeah, but there's no easy answer, Janice. You have to keep asking different ways to hint to him. Really, you must answer this. You may have to even you may have to do a last one. What else can you remember about that day?
Yeah, I think the struggle was more not so much asking the question, it's objections to, you can't ask a question in re that doesn't start with sila terangkan, or can you please explain? He can only explain, you cannot ask a question. And I found that a real challenge because sometimes
once
there's no way to ask.
Once you contextualize that area, when he starts explaining, you are entitled to keep asking him to explain the same thing.
Yeah.
And go into areas that follow-up questions are fine to me. Is that Miss Jessie with you?
Did you hear her voice?
No, I saw her face.
Oh, okay. Yes.
Which Jessie is that?
It's happy hour with Pravin Jessie.
Okay. Is Pravin the one who met me in Tokyo for the Rugby World Cup one day?
Did you meet him in Tokyo? Yes. Yes, it's her. Okay, happy birthday.
Sorry, okay, that's the answer to the question.
Together with some Rugby World Cup stories.
Yeah.
Thanks, Brendan.
Three rows in front of me.
Okay. I'll remind her.
Actually, Brendan, just to, I had a follow-up question to last response about the re-examination questions. You mentioned same context insofar as the answers that can be given in re-examination is concerned. But to me, sometimes same context and a different giving an answer that strays into a new area can sometimes be a bit blurred. The distinction between those two concepts can be a bit blurred. How do you explain that? How do you clearly define what same context means and what straying into a different area means in the context of a re-examination answer?
I think high court judges understand it better than lower court judges. High court judges, if it's generally the same area, they allow the question because you're trying to correct the earlier evidence it crossed. So long as it's within that same subset area about the agreement, and why did he say the agreement was not signed, for example, you can keep asking question to explain why the agreement was signed. So it should, in theory, be not so strict in that sense. But the lower courts are like much more strict. They look like, no, you must only ask this, you cannot ask anything else. But the high courts are more like, the general area is there, let him explain. And that's because in Malaysia, and it doesn't happen in Australia and UK and South Africa, in Malaysia, we have this more than yes or no. So for all the junior lawyers, in UK and all that, there's no such thing as interrupting the witness saying, no, my question is very specific, you answer yes or no. You can't do that in Australia or UK. If the witness wants to explain, he's allowed to explain. So it's only a Malaysian thing where we stop witnesses from explaining. No, your lawyer can ask you to explain later. Now, once they stop you from talking, stop the witness from talking in cross, in all fairness, when it comes to when I say, why did you disagree? I can ask as many follow-up questions as I want because you were the one who didn't ask the explanation earlier. So my answer to anyone objecting to re would be, sorry, when this question was asked earlier, you wanted a yes or no answer. Then you said, can explain later in re. Now I'm asking you to explain in re, and he's explaining. So why are you asking me to you can't limit the answer in cross and then limit the answer in re. So that's one technique I do. So, sorry, my lord. He did force my client to answer yes or no, even though the client had more to explain. And now the client is explaining, is what I would say usually.
Thanks, Brendan. Are there any other questions, Zah? Did you have any follow-up questions? Or?
Yeah, I just have one actually, Greg, if that's okay.
Sure.
Yeah, Brendan, you stressed the importance of getting straight to the point, and because judges don't like advocates to waste their time, but at the same time, you also stress the importance of building your questions. I remember you saying build 5 questions and then put your final questions, right? How do you strike a balance between getting straight to the point, but at the same time building your questions? I find that I struggle with that when it comes to cross-examination.
Okay. Good question. The general advocacy point I made earlier about getting straight to the point was for submissions and for your witness statements and your written work. But there will come a time in cross where you don't get straight to the point because you want the witness, you want to take the witness through slowly each step of the way. It's called a slow burn. You know what your objective is, and you want him to burn slowly and squirm as he goes along. Yeah. But in doing that, you are still asking sharp questions that are relevant. You are taking more time, but the questions are all relevant. So you are not beating around the bush. So instead of saying, do you agree that what you should have done is this, this, and this, and that, you ask one at a time, one at a time, one at a time. But that is not the same as meandering, waffling. Judges don't like that. But if the questions are sharp, one at a time, it is taking a long time, but it is to the point, Every question is to the point. Yeah. So they don't see that as a waste of time. They don't see those questions as a waste of time. It's taking 20 questions to get there, but each one of the 20 questions are relevant. So you must be careful that if there are 20 questions, not one or two of those 20 questions are something else not relevant. That's another mistake people make. If you want a judge to follow the proposition you want to make, all the questions you asked earlier must be relevant to that point. If one question is not relevant, it goes somewhere else, you lost the judge. They're thinking of this and that, and all, they're not following. Yeah. So yes, sometimes it takes longer, but to them it's not longer because you're still on the same point and you're making the point concisely and short. So those things they don't think is a waste of time or wasting their time.
Thank you so much, Brendan.
But you're right. If you can achieve the same objective with 5 questions, why ask 20 questions?
Brendan, I think we have taken up far too much of your time. 40 minutes over.
7 o'clock.
Thanks so much, Brendan, for your time. That was
just one last point about that, getting straight to the point. So yeah. I've tried to do that for talks as well. The talks I do for council, talks I do for Kialba. I know some of your speakers before would be from overseas, and I noticed that overseas speakers, they tell jokes in between, they tell stories in between to get to the point. I like getting straight to the point, and that's why I told Greg we've got a lot to cover. But it's just getting straight to the point and telling as many things as possible so that the young lawyers understand everything. And that's what we do for our talks. So if I could plug the talks, not the talks, if we could plug the advocacy training courses that we do, I think Janice does it, Stephen does it, David Matthews does it, and Greg's coming into the fold soon. There are advocacy trainers out there, and the courses are very well received. And if you haven't done it so far, try and sign up for one of the courses, because you'll get a senior lawyer to come and help you for a good weekend helping you with your advocacy. Sorry, I just had to plug that.
No, thanks for that.
Janice teaches the advocacy course. So if you have any questions about the course, she can answer your question.
Yeah, I attended the expert witness handling course a couple of years ago, and that was really, really good.
When you get the witnesses telling you how they felt.
Sorry?
Especially when you get the witnesses telling you how they felt when you performed.
Exactly.
Very valuable.
Yeah. It was quite, at the start, I found it a bit disheartening because I was just doing a lot of things wrong. But then, it was such a learning process, and it's so many things I apply in practice today. So it was really, really helpful. And this talk as well was very useful. Thanks so much, Brendan.
No problem at all.
Thanks.